He said he ain't do it, but the state had Alfred said, I got people that'll testify that I ain't do it. What happened is they interviewed those people and they wasn't saying he didn't do it. They were saying, yeah, he might have did that.
So would you defend a murderer? Would you defend a rapist? Our job isn't to wave a magic wand and trick people into thinking that something different happened. The best way to look at it is,
now, if you're not ready, then go ahead and tell me you're not ready.
I object to you getting records. You've been intrusive into people's personal lives.
In other words, the car didn't hit him, and he wasn't hit by the car.
I'm not a lawyer, but
are y'all keeping up?
I'm not a lawyer, but
the debrief.
Hello, and welcome to another episode of I'm Not a Lawyer, But
the debrief.
I am Melanie, aka I'm Not a Lawyer, But, and I'm joined by my co-host
Goosebay. How y'all doing?
And before we kind of dive into the episode, we want to give a shout out and a thank you to our sponsors, which are Factor and BetterHelp. And we are going to tell you more about them in this episode. We are not lawyers or legal experts in any way, shape, or form. But that's what this podcast is called. We emphasize the fact that we're not lawyers, and we get on here and talk about legal things that are happening, give our perspective, thoughts, all of the above. And so that's what we finna do. To start off, today, this episode is being filmed on Thursday with our Patreon Live.
Mm-hmm.
And the news has just hit that Rich Homie Quan has passed away at the age of 34, unfortunately, very young. His given name is DeQuantus Devontae Lamar. But again, obviously known as Rich Homie Quan to many of us.
Mm-hmm.
And that is sad and just felt like appropriate to highlight, share, emphasize. Obviously, rest in peace to him, and love and prayers of strength to his friends and family and anyone who loved him. He has, of course, been brought up many times in the YSL trial that we've been covering for a very long time. He was someone who was on the state's witness list, who was expected to be testifying. He was brought up many times in the testimony of Kenneth Copeland, aka Woody. And so anyway, to hear this news is really unfortunate, really sad. And so again, love, prayers, thoughts to everyone who loved him. He had some hits for sure and songs that we listened to for sure. Anything you want to add to that?
No, you covered it.
Okay, so with that, we will transition into the episode. All right, so we are going to talk about the YSL trial because some things have happened this week that I thought would be good to give some context. Woody finished after 16 days of testifying. He finished being on the stand for now because he is still under subpoena and the state can still call him back. But he, for all intents and purposes, is done.
The state can still call him back
anytime
after
you're subpoenaed,
all of that?
Yeah. When you leave, the judge asks for every witness, is he done or do you expect to call him back? And they say yes or no. So
my goodness,
he could still be, but again, for all intents and purposes, he is done for now.
That would be wild if they call him back. If they haven't asked him all the questions in the world.
Yes.
Already.
I'm interrupting only because Dominique in the chat is talking about the Karen Reed 2020. We are planning on watching that with the Patreon, just FYI. I think I said it. I don't remember if I said it in a live and maybe not like publicly to everybody, but our intention is to watch that live with y'all. I will send the link and all this stuff, but that is the intention. Anyway, let me get back into the mode. So the next witness has been called to testify, and that is Antonio Sledge, aka Muntunk is his name. So he has been called to the stand, and what's interesting about him and his testimony is that he was one of the people, unlike Kenneth Copeland, which people get confused sometimes. So probably important to emphasize. Unlike Kenneth Copeland, who was not a co-defendant on the indictment, okay? To be very clear, Kenneth Copeland was not indicted on this RICO. He is not a defendant. He did not take a deal to get out. Well, that we know of. He did not take a deal to get out of being one of the people sitting in them chairs next to Thug, okay? Not a defendant. So unlike him, Antonio Sledge was a co-defendant, okay? He was one of the people indicted in this RICO. He just took a plea deal, a guilty plea deal back in December of 2022. Of course, they were handing out for people that they wanted to. They was handing out plea deals. If you don't want to really do this, okay, you want to admit your guilt now, we can give you a sentence and you can move on, be on about your way. So Antonio Sledge took a plea deal, and actually, let me pull it up just so we can see what we're all referring to. So y'all can see what I'm referring to. Is a better way to say that? So if you are listening and not watching, this is the plea deal, guilty plea deal that he took for the RICO trial. Okay. So in this RICO, he was charged with count 1, which everybody was charged with, which is a conspiracy to violate the RICO Act. Basically, everybody, it's a RICO Act because the allegation is that all y'all violated the RICO Act. Okay. So everybody has that charge. And then the second thing he was charged, the second count he was charged with was possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. Okay. So that is what he was charged to in this. Now, he accepted a guilty plea. Okay. He accepted a deal, which says that count 1, they sentenced him to 15 years to serve on probation. So 15 years probation for violating the RICO Act. That's what was negotiated. For count 30, which is that possessions charge, they said sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided that the defendant complies with the special conditions outlined in B, C, D, F, and I, okay, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to no pros, which is basically not prosecute him, okay? So basically, they're like, hey, 15 years for violating RICO. For this possession charge, as long as you agree and you do what B, C, D, F, and I say, then we won't even prosecute you. On the other one, we'll make that go away. Okay. So B, C, D, and I, right? B, C, D, no E, B, C, D, F, and I of the special conditions include testifying about what he says are factual acknowledgments. Okay. So basically, he has to testify, and you have to testify according to what's in this agreement, what the factual acknowledgments are. Okay. And so when you scroll down further, these are the factual acknowledgments. I hope you guys are following, right? Like in order to accept a plea, you have to kind of a guilty plea. Like, what are you agreeing to exactly? That's what factual acknowledgments are. Like, what are the things that you are acknowledging are fact, right? That's what this is. So the first one, which all of the pleas have had, is that Young Slime Life, aka YSL, is an organization made up of 3 or more members who share common identifiers that include colors, hand signals, terminology. Basically, if you're blood, you wear red and you change the C's to B's. That's essentially what like number 1 is getting out. Number 2 is that he has been a member and or associate of YSL since 2012. And then 3, 4, and 5 talk about a drive-by that happened on, if you see number 4, it says on or about April 28th, 2015, as reflected in this other indictment. Antonio Sledge, Demikion Garlington, and Quindarius Zachary, all YSL associates, committed a drive-by shooting using the firearm that he uses in a video, targeting family members of a rival gang. And that action was done, according to number 5, to increase the notoriety, reputation, and fear of YSL. Obviously, meaning it's a street gang, and y'all were trying to basically like flex a little bit and
Yep.
make sure people know don't mess with YSL. Okay.
Mhm.
Number 6 says the defendant, meaning Antonio Sledge, admitted committing and was convicted of aggravated assault, participation in criminal street gang activity, among other charges for his participation in the drive-by shooting that's referenced. So basically, this drive-by happens, he gets indicted, and what number 6 is saying is that he admitted guilt and was convicted of aggravated assault and participation in a street gang related to. So those were the charges that came out of that drive-by shooting. Okay. That's the context here. There's some other things. He also says that he was told about the murder of Donovan Thomas and that everybody went to McDonald's and that Jeffrey Williams, aka Thug, paid money to get everybody to lay low, all this kind of stuff. So that is his plea deal. And he's been up on the stand and being asked questions about that.
And this plea deal is 2022.
Correct. That is
Okay.
the plea deal from December 22. And it's essentially why he is on the stand right now testifying,
Mhm.
because that's a part of what you agreed to. And the
Mm.
other thing, I took it off the screen already, but the other part, the sentencing acknowledgement of the deal is that as long as you comply and do everything we said, we'll make this other one go away. In the event you don't, in the event you get on that stand and start lying or say anything in this thing is not true, then we can sentence you for that second charge up to 35 years. Okay?
Ooh.
So that is the risk, the gamble he's taking. As long as you abide by it, everything's fine. If you get on there and act crazy, we can sentence you up to 35 years in prison. All right? So, what happens yesterday, which was Wednesday, is that Antonio Sledge is testifying, and there was a moment when Attorney Love, the prosecutor, was about to start referencing things in this plea deal. Basically, like, number 1 says that, this was a gang and they had colors. Are you saying that's true or not?
Mhm.
Right? And so she was about to essentially not read directly from it, but she was about to start being very specific to it. And so Bruce Harvey, okay, who is one of the other attorneys, he says, "Hey, judge, can you read a limiting instruction?" Okay, which is not unheard of. Basically, you got to follow this because it's a lot. Basically, the judge reads to the jury, "Hey, you're about to hear some statements from this man's guilty plea. You, as the jurors, cannot assume that just because he pled guilty to what he was charged with, that means that any of these other co-defendants are also guilty of what they are charged with. That doesn't
Mm.
mean that. It just means that he is acknowledging and accepting guilt on what he did and what we charged him with.
Mhm.
That is separate than what these people are charged with." So that essentially is the first half of her limiting instruction.
Okay.
The second half of the limiting instruction got a little tricky. She says, "Okay, you can't hold that against them. However, if what he acknowledged in his plea deal, meaning Sledge, if what Sledge acknowledged in his guilty plea, if he gets on this stand and says anything contrary or contradictory to, he says
Mhm.
anything other than what he said then, you can use what he said in the deal against everybody." Okay? And so, as an example,
Oh man.
he said, "Yeah, after the death of Donovan Thomas, Jeffrey Williams paid for everybody to go to Miami."
Mhm.
Okay, he said that in the deal. Now, if he gets on that stand and they ask him and he's like, "That didn't happen, I lied," what she's saying is you can hold what he said against Jeffrey Williams
Mhm.
because that is actually meaningful.
Yeah.
So it is worth something, essentially. Hopefully that makes sense. Okay, so she tells the jury this, and then she says, "Okay, go ahead, Miss Love. Go ahead, prosecutor."
Mhm.
So then Attorney Love starts reading from not Antonio Sledge's 2022 guilty plea.
Mhm.
She reads from the 2017 plea that Antonio Sledge agreed to regarding the drive-by shooting. Okay.
Okay.
So warmer, sunnier days are calling. Fuel up for them with Factor's no prep, no mess meals. Meet your wellness goals in time for summer thanks to our menu, chef-crafted meals with options like Calorie Smart, Protein Plus, and Keto. Factor's fresh, never frozen meals are dietitian approved and ready to eat in just 2 minutes. So no matter how busy you are, you'll always have time to enjoy nutritious, great tasting meals. Make today the day you kickstart a new healthy routine. What are you waiting for? With 35 different meals and more than 60 add-ons to choose from every week, you'll always have new flavors to explore. Crush your wellness goals this month with dietitian-approved meals and ingredients that you can trust. Treat yourself to restaurant-quality meals that feature premium ingredients like filet mignon, shrimp, and blackened salmon. School is back in session. It's still warm out, but school is back in session. And I am running around. Greg is running around. We are doing a ton of things. And so having meals, okay, that don't require prep and aren't messy when you have children is always a win for me. Okay. And the meals are good. Factor has good taste in food. And so those are the things that I need in my life. So head to factormeals.com/lawyer50.
Lawyer50.
And use code lawyer50
Lawyer50
to get 50% off of your first box plus 20% off your next month. That's code lawyer50
Lawyer50
at factormeals.com/lawyer50 to get 50% off your first box plus 20% off your next month while your subscription is active. Thank you, Factor, for sponsoring us. And y'all sponsor, go get you some Factor meals, put our code in, okay? Because you're gonna love it. In the 2022 for the RICO case, number 3, 4, and 5 referenced this drive-by shooting from 2015, okay, and said that he was charged with aggravated assault and criminal gang. In that case, Antonio Sledge took a plea, okay? She reads from that instead of what everybody thought she was going to read from, which is 2022.
Okay. That's why I was confused.
Now, the problem with that, okay, is that the plea that Antonio Sledge took in 2017 for the drive-by was not a guilty plea. Okay? When you do a guilty plea, it means, hey, I'm guilty. I did that. Okay, I'm sorry. He did an Alford plea. An Alford plea is basically, I get to maintain my innocence. Okay? I ain't do that. But also, I recognize that y'all got a whole lot of evidence against me. And it's probably not a good idea for me to go to trial, because if the jurors don't see it my way, I'm gonna get a really bad sentence, and y'all got evidence. So what I would like to do is maintain my innocence, okay, while also what y'all gonna sentence me to, because I'll just go ahead and serve that.
That's wild that this is even an option.
Well, and it comes from, okay, a North Carolina versus Henry Alford case from 1970. The man's name was Henry Alford, and that's why it's called an Alford plea. What happened in that case, again, it was North Carolina. What happened is that Henry Alford was charged with first-degree murder, okay? He said he ain't do it, but the state had Alford said, I got people that'll testify that I ain't do it. What happened is they interviewed those people and they wasn't saying he didn't do it. They were saying, yeah, he might have did that. He told us he was going to do it. We watched him leave the house with the gun. And then when he came back, he said, hey, I just killed that person. Okay. So it was like, oh, y'all got a lot of evidence, but I promise y'all I didn't do it. So what happens is that if you plead guilty at that time in North Carolina, if you pled guilty to first-degree murder, you got life in prison. If you took the chance and didn't plead and just went to trial, and the jurors convicted you of first-degree murder, you would get the death penalty. And then the sentence for second-degree murder was up to 30 years. Okay? And so what happens is he pled guilty to second-degree murder. Hold on, I just want to make sure I'm saying it right. Yeah. So he pled guilty to second degree because he didn't want to die. He didn't want to go to trial and then see what happened. I'm going to be dead, right? And so as he's accepting the guilty plea, one of the questions they ask is, are you entering this plea voluntarily, willingly, and like fully understanding what this means? And he says on the stand, I'm only doing this because I don't want to die. The other option for me is to be sentenced to death. So he gets sentenced, whatever. It essentially he appeals, and it goes up through the Supreme Court, and it goes back. A lot of courts ruled that no, that's what he got. You can't appeal. You accepted it, so it doesn't matter. But it goes up to the Supreme Court, and they ruled that his motivation was very much he didn't want to die. It wasn't like a true, absolutely like I'm entering into this plea because I am guilty, or like honest motives. It was the other option is to die.
Yeah.
And so because of that, the Supreme Court basically said that even if the defendant maintains their innocence, as long as a guilty plea is constitutionally valid, so it is a valid plea, if the defendant maintains their innocence, as long as the plea is made voluntarily and there is a strong factual basis for the plea. And so the court reasoned that the defendant's decision to plead guilty, meaning Alford, the reason he pled, even while claiming his innocence, was an informed choice made to avoid the potential of a harsher penalty, meaning the death sentence.
Now, I wonder why the state, whoever he's against, would let him do that when they have so much evidence on him. Like, you're guilty, and we're going to prove it, and we won't have to make a deal with you type situation.
Say the question again.
If I have all the evidence to find you guilty, why would I not go to court?
I think I'm not a lawyer, and I would need somebody to confirm, but I imagine that most prosecutors would prefer pleas. They don't want to go to court.
Yeah.
They don't want to have a trial.
All right, man,
they
get
would
out of here.
prefer you say, you caught me. Okay. Versus weeks of a trial preparing.
Yeah.
And think about, this is the other wild thing when it comes to like having an attorney, and when you have money, it's better for you as a defendant, because the state pays for experts. The state pays for witnesses when they have to come in. And if you are a defendant, you got to pay for your side. If you want a witness to come in and say, and maybe they don't live there, and you're like, this person will verify that I was not where y'all say I was, you got to pay for them to come. You probably got to pay for them to be served. You got to pay for their stay. All that becomes your bill. And so for the state's case, it's their bill. The state has how many witnesses in this case? Guess what? Everybody that's coming to town, everybody they are paying for. It's expensive. It is expensive. So I would imagine they would prefer you plea. But
I agree.
All of that to say, the point there was the document that Attorney Love reads is from an Alford plea in which Antonio Sledge never admitted guilt. And yet she reads from this document the allegations about that drive-by as if it's fact, and as if he was
and she's doing this in front of the jury.
And she does it in front of the jury. And I just want to pull this back up, because if you see number 6, it says the defendant, meaning Antonio Sledge, admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in section 3, 4, and 5. What did I just tell y'all? It was an Alford plea. He never admitted committing. He never was technically, I would say, convicted of, because it wasn't out. He actually maintained his innocence. So the fact that this 2022 guilty plea uses a plea from 2017, but does it incorrectly, I was like, bruh, this feels like shaky ground. I don't even know how you're able to use that. It feels like number 6 in and of itself becomes invalid. However, go ahead.
I don't understand how something as heavy as this can be told to the jury and the case move forward.
Oh, yeah.
Like,
and there's more. There's so much more. Well, but let me just say that he had an attorney. So the fact that his attorney allowed him to sign this 2022 plea deal even though it incorrectly references the 2017 plea deal. I
Mhm.
would imagine the issue is probably waived. But in looking at it, it felt very shady. It felt very problematic. Y'all knew that that was not a guilty plea. It was an Alford plea. And so the fact that she got in front of this jury and read out the allegation, she was like, so, and this is the factual basis for the deal. And she's not saying Alford. She's just saying for the guilty plea or for the deal you took. So she's like reading out to the jury, in 2015, you, Demikion Garlington, and number 3, I can't remember his name, you guys went to the rival gang member's house and shot it up, and you were the driver. And then from there, you went to a second house, and then you guys shot that place up, and this lady was shot in the butt, and this happened, and she's just stating all of this as if it's just fact and as if he agreed to it. So what ends up happening, I have to hurry up. What ends up happening is that Brian Steele, Jeffrey Williams' attorney, realizes, hold on, she's reading this
As if it's fact.
as if it's fact and from an Alford plea. So he objects and he motions for a mistrial. Okay. The judge is upset about it as well. She gives everybody opportunity to make their claim. And Bruce Harvey, who is very slowly becoming my favorite, he says something that I want to play, because there's one more thing that's really interesting about it.
It is so highly prejudicial that we all made a motion for mistrial. A rebuke is in order under 17875.
Okay, so Bruce Harvey mentions a Georgia code, okay? He mentions Georgia code 17-8-75, which says improper statements by counsel. So he says that, judge, you need to admonish her and you need to rebuke her, right? And so this is what he cites, right? This code. And it says, where counsel in the hearing of the jury makes statements of prejudicial matters, this is prejudicial, which are not in evidence, it is the duty of the court to interpose and prevent the same. On objection made, okay, as long as they object, the court shall also rebuke the counsel and by all needful and proper instructions to the jury endeavor to remove the improper impression from their minds. So basically, she was wrong, wipe that from your minds. Or in his discretion, he may order a mistrial if the prosecuting attorney is the offender. Okay? So what happens after Bruce Harvey does that, says his objection and raises this code? The Attorney Love is still talking. And so she's like, Attorney Love, you might basically want to be quiet unless you want me to order a mistrial. And she's like, no, I don't want you. And it was so odd because it was like, why would she threaten just order the mistrial? And what you see, according to that code, she was well within her right to do so. She just chose not to.
That code bullseye right on Attorney Love.
So it absolutely could have been very valid. Everything else, a lot of times they'd be like, mistrial, mistrial, mistrial. And they'd be like, bruh.
Yeah.
But she was well within her right, according to that Georgia code, well within her right. She could have done it. So anyway, Judge Whitaker ends up admonishing and rebuking her in front of the jury in the courtroom. Quite the sight to see. Quite the sight to see. So, and actually, I'm going to play a quick clip and then we will move on because we have a guest. I told you guys earlier, we have a guest, so we're going to get to that. But let me just play the admonishments and the rebuke.
And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right.
All right. So that's our YSL wrap up for the day. We are going to transition because we have a guest.
A guest. There we go.
What's something you'd love to learn? As an adult, do you make time to learn new things as often as you'd like, or was that lost in childhood? Because everybody's busy and nobody has time to do the things that you dream of. You just are like constantly moving, right? Kids are always learning and growing, but as adults, sometimes we lose that curiosity. What's something you'd like to learn? Is it gardening, a new language, or maybe how to finally beat your best friend in bowling, which is something I am actually not good at all, and Greg is very good at? Therapy can help you reconnect with your sense of wonder because your back to school era can come at any age. I love that. Your kids are back in school. You can too. Get to learning. That's great. If you are like me and feel like you're on a hamster wheel and would love time to just like say things out loud to somebody else who's paid to listen to you, I think that's also very key, right? When you talk to people who, number one, aren't paid to listen to you, and number two, aren't experts or trained or specialized in being able to listen, that could get real dangerous. Number one, because people who aren't paid, they be interrupting you all the time. And when you have a therapist, they don't do that. Okay. BetterHelp can help you get somebody who doesn't interrupt you the whole time you're talking. And it can just help you when you put things out, when you say them out loud and out of your head. I feel like it's just, you can realize like, oh, I may have been tripping. I was a little bit off right there. So anyway, that's been my experience with therapy and how helpful and useful it is to me and why I always recommend it. So if you are like me or anyone else and you're thinking about starting therapy, give BetterHelp a try. It is entirely online, designed to be convenient, flexible, and suited to your schedule. Just fill out a brief questionnaire to get matched with a licensed therapist and switch therapists at any time for no additional charge. Imagine being able to have somebody break up for you. That's essentially what BetterHelp can do for you. You don't have to break up with them. You don't have to like send that awkward like, hey, I don't want to see you anymore. It's not you, it's me. BetterHelp does that for you. And that alone is a benefit. So rediscover your curiosity with BetterHelp. Visit betterhelp.com/lawyer.
Lawyer.
Today to get 10% off of your first month. That's BetterHelp, HELP.com/lawyer.
Lawyer.
You gotta do it like me. Lawyer.
Lawyer.
Now back to the show. Okay, so our guest for today is a criminal defense attorney who is based in Jacksonville, Florida. His name is Obinna. We're going to call him Obi. And he is here to talk about some Florida things that we have questions about. We've been discussing on this podcast. And so we are excited to have an actual lawyer come in and fill us in, tell us all the things. So thank you for being here.
Hello, Obi.
Thanks for having me. Thank you, guys.
So first, let's do a bit of an intro of you. Can you tell us, we said criminal defense attorney. How long have you been practicing? Where are you originally from? Give us some tidbits before we kind of dive in.
I'll give you the short version, as short a version as possible. I'm from Los Angeles. I was born and raised there to a Nigerian father. That explains the name. He immigrated here sometime in the 80s from Nigeria.
Okay.
I was raised in Los Angeles. I went to school in Long Beach. Then I came here to Florida, to Jacksonville for law school, and I started a family, and I haven't left. I've been practicing now 10 years.
Oh, wow. Amazing.
Oh, that's cool.
I appreciate it.
So
you left California and never came back.
don't get him
Well, I
started.
come back to visit,
Yeah.
but I like to keep the money in my pocket here in Florida,
yeah.
Tell
There we
me
go.
about it. Tell us about it. Okay, so we had been covering on this podcast the case of Susan Lorenz, who was charged and convicted with the murder of she was charged with manslaughter of A.J. Owens. And a part of her defense was self-defense. And so it just really sparked a ton of questions for us as far as what is self-defense. I don't think we're convinced, not even think, we weren't convinced it was self-defense, but in a general census, can you talk to us a little bit about like how is self-defense defined, if that is a way, a thing you can do?
Well, as it relates to this case, Florida's law says that you have a right to carry on about your business if you're not doing anything illegal. You can mind your business. This is kind of based on an old English law, something we learned in law school called the Castle Doctrine. Essentially, and that applies to your home. Like if someone comes to your home, to your castle, you have a right to defend your castle with reasonable force.
Okay.
Okay. Now Florida's stand your ground law kind of expands on that and says not take away the house, take away the castle. You can just be in the Walmart parking lot. You can be anywhere, and as long as you're not engaged in unlawful activity, you can use force, even deadly force, to defend yourself, but only in this if you personally fear great bodily harm or death.
Okay.
And in the case of Miss Larynx here,
Yeah.
I believe this is a case where there had been an ongoing dispute between Miss Larynx and the AJ Owens, the victim here, and regarding the kids. And I believe that Miss Owens came to Larynx's residence and she banged on the door to confront her, to talk to her about why she had earlier that day, I believe, thrown a roller skate or something at a child and maybe did some other things. And this is again an ongoing dispute. So AJ Owens comes to confront Miss Larynx at her home. Miss Larynx, and this is the important part, she's behind a solid, I believe, metal door. Okay.
Yep.
A door, and she can see outside the door. She can see Miss Owens approaching, but she
Well, she
fires
didn't have
one
a
shot.
peephole. She didn't have a peephole in her door.
She didn't have a peephole, but she was behind that
Yes.
door. She was behind that door. She was reasonably safe. It appears the jury seemed to think that, and this is why we have a conviction of manslaughter in this case.
So you said you have to believe that you are in imminent, what'd you say, fear, in imminent danger of.
In fear of imminent great bodily harm or death. And so that can mean a lot of things, and that's actually a question for a judge or a jury, depending on the circumstances. We can get into that, but essentially, if the judge or the jury, the fact finder, whoever it may be, believes that you personally had that fear and it was reasonable, then you are justified in using deadly force even to defend yourself under those circumstances.
So here in California, they have, well, I don't know if it's in any other states, but if someone breaks in your home, you catch them and they flee, right? They're running out of your house and you shoot them in the back. They say that's not self-defense or standing your ground. That's
It's not. It's not in Florida either, because the threat, if someone's running away from your home, the threat is past. The threat is literally running in the other direction. There's no reason to use deadly force at that point. It's not reasonable, one would say.
So in certain situations, in our home, there's a straight line in the hallway from my bed down the hall. So if someone would have broken into my home and they hear a gun cock, I can barely see them, but I know they're there and they take off. I don't know if they're running towards me or away, and I fire. That's just a
So
situation that you leave up into the hands of the judge and the jury.
that would be a fact finder question there.
Yeah.
The jury or the judge would have to determine after hearing. I assume. I'm sorry. I'm going to put this on do not disturb here,
No worries.
so we're not getting interrupted. Now the jury is going to have to believe that that the self defense that I guess in the situation that you're describing here, if the jury were to find that you reasonably did not know whether you were out of danger or not, and someone is in your home, the jury or the judge could find that you reasonably use self-defense or deadly force as self-defense in that case.
Okay. So staying your ground and self-defense isn't a concrete type thing. You still have to convince people that you were in danger.
Right.
Yeah.
It's not a get out of jail free card.
Yeah.
Certainly not.
You mentioned great bodily harm, which feels a little loose and could be left up to interpretation. Is that
There's a lot
accurate?
of
I mean,
gray area
I
there.
was going to say law feels like there's a lot of gray area and a lot of what you can convince people of.
Right.
What is that? It feels so broad.
Right. Now, this is what we call gray area, right? And you're going to find this a lot in law. Actually, in law school, all we do is read appeals cases, and this is where the gray area comes in, right?
Yeah.
So we understand that term generally, great bodily harm. So then the question is, how do you define that more specifically? The answer is we call it case law. So there's been other cases like Ms. Lorink's case, where an appeals court has had to determine and answer that question: what is great bodily harm? And they've written their opinions down on paper and they've published them, and lawyers and the public can read them, and their opinions of these judges are considered binding on whatever lower courts are under them. So if the Supreme Court of Florida defines great bodily harm in a case, writes an opinion on it, then the rest of Florida has to abide by it. That's the Supreme Court. That's the highest court here. We also have, I believe, 5 or 6 district court of appeals, which are still a court of appeals higher than the trial court, which is where Ms. Lorink's case was, and then obviously a step below the Supreme Court.
Got it. I saw a question I wanted to ask, in the case of, this is a little bit of a flip from self-defense and stand your ground, but in the Susan Lorenz case, do you have thoughts on why she would get manslaughter and not second degree? Can you talk about what the difference between those are and then why one versus the other? I assume prosecutors want to charge you with what they think they can get you on, but tell
It's a
us.
great question. It's a great question. I believe in this case, the prosecutors, and they stated as much. They went with the charge that they knew that they could prove, which was manslaughter, and it is a lesser serious charge than second degree murder. So second degree murder is, if you want to, it doesn't apply in this case, I don't think, because, and it could, but it's a stretch to prove second degree murder. They would have to prove that Ms. Lorink's developed at some point an intent to murder or to harm, to a great extent, Ms. Owens, and to kill her, and I think that you probably don't have that here. You have a woman that was reckless, and the manslaughter charge is appropriate because she used that gun, she fired it, and she reasonably should have known that it would have caused unreasonable harm to another person, specifically Miss Owens on the other side of that door.
So the biggest, go ahead, sorry.
Yeah, and that's a lot easier to prove than to prove that Miss Lorink's knew that if she fired her gun that it was going to kill Miss Owens, and that is what she would have to prove, I believe, to get a second degree murder conviction.
So the biggest difference, correct me if I'm wrong, this is a question, it's going to sound like a statement. The biggest difference between a murder charge and manslaughter would be intentionality versus like reckless behavior. Is that
That's a
accurate?
good way of putting it.
Okay.
Yes.
Okay. Got it. That's interesting and a good call out.
In what cases, I'm so confused on this. Well, I guess I'm not confused. If I feel like I'm in danger, I have to convince people that I felt like I'm in danger.
So that's, there's a lot of ways that you could prove that, and then you could theoretically think of almost any type of evidence you can introduce. It could be your own testimony. It could be the testimony of others. You can perhaps introduce exhibits, pictures of defensive wounds, medical records. The totality of the evidence is what's going to be considered when the fact finder is determining that important question.
I'm saying this because when it comes to police officers shooting people, they always say they felt like they were in danger, and then that person doesn't have a weapon. The person is sitting in a vehicle. how are these police officers convincing judges and juries that they're in danger, or they felt like they were in danger when it's obvious that they weren't in danger? That's where I'm just, it'd be blowing my
I
mind.
think that it's the power of the uniform. These police officers, they come into court and they always make it a point to wear their uniform because they know the effect that it has on the average public, which is this is a person who's taken an oath even before they took an oath here in this courtroom today to protect the public, to serve the public.
Mhm.
Automatically, this individual, this person who's clad in uniform is going to be held up in the mind of most jurors as an honest person. Um, that's probably why you see that to a greater extent the police officers getting away with perhaps unjustifiable deadly force.
Mhm.
Um, and then you also that it's just the dynamics of policing, right? The people, the average person won't have a negative encounter with the police. I'm from South Central Los Angeles, so I understand y'all out in California. You're probably familiar.
Uh-huh.
The police are like gangbangers there,
Yeah. So we've heard.
Um, so it's a mess. It's a mess, and I don't think that it's fair. But here we are.
One of another Florida case, actually, and people are bringing it up in the chat as well. And one that I like, one of the first, actually, it's the first video I ever posted on TikTok that got me like 1 million views, was the Travis Rudolph case. The football player who was charged after he had broken up with his girlfriend. He played for somebody that was like blue and green.
I want to say Jaguars. Was it Jaguars?
Okay, so he played at college, at Florida State, and then he went to New York Giants and Miami Dolphins.
Oh,
They're
totally
blue and green.
wrong.
That's where I got that from, huh?
Yeah.
But anyway, what happened is he had broken up with his girlfriend, and she had called her brother and some friends, and they went over to his house around like midnight, and his brother comes to the door. There, altercations, some yelling and all that stuff. He grabs a weapon, puts it by the door as he's like opening the door, I believe. And so there's a bit of a scuffle between his brother and the group
friend.
of men who came to his house. And I believe what was said, if I can remember correctly, they're in the vehicle, and he said that he either saw or they for sure were shooting. And so he shot as they are shooting, he was found not guilty. The charges were the juror said he was not guilty, but he shot at them, and his claim was self-defense, which was interesting.
So yeah, this is exactly what the law kind of in Florida. This is exactly what the law kind of puts into perspective here. Is a situation just like that where I guess if you're the jury, what you're hearing is that this man knew that these gentlemen were coming to perhaps confront him, if not assault him. Perhaps he had some reason. I don't know if he had any reason to believe they were armed. Perhaps he did. And in Florida, there's enough reason to assume that everyone's armed here.
Yeah, you can assume.
So there's that. And then, I'm guessing that probably was an odd time of day for someone to be showing up at his house. The totality of the circumstances again can lead a fact finder to believe that this man, that Travis Rudolph, used self-defense or used deadly force rather as justifiable self-defense. It's feasible.
I have more questions, but it's going to transition just slightly off of the stand your ground and the self-defense. So I just wanted to ask if there's anything I didn't ask you that you just want to like point out or be clear about any of those. I wanted to give you time.
So we talked about the judge and the jury, right?
Yep.
Now I believe it was 2017. We had the stand your ground laws at least as far back as the Trayvon Martin case, which you may recall. But something happened in 2017. Something changed. So now it's the state's burden to prove that the the act of self-defense wasn't justifiable. It used to be the other way around. Now the burden's on the state. And so what that means is that you're entitled as a criminal defendant in Florida to have a hearing in front of the judge before you've even gone to trial, for the judge to have what we call a stand your ground hearing,
Oh,
to
yeah.
make that determination right there on the spot, after hearing evidence, was this self-defense and was it justifiable under Florida stand your ground laws? And then the prosecution ends right there.
I remember that being talked about actually for this case, because for the stand your ground hearing, there was a hearing for it, and the judge determined that basically it's enough to keep going, to go on to trial.
Yes, and it's actually the same thing that happened in the George Zimmerman case. That went to trial, and then obviously a different result there. But yes, there must have been a stand your ground hearing in the Lawrence case.
And in that hearing, that is up for the judge to, it's not her always, obviously there's male judges, but it's the judge's decision.
Yes, then the judge would be the fact finder in that case. At trial, then it's going to a jury of your peers.
Got it. Actually, I think
I like that better than me having to prove that it was self-defense, because you're going in the court case saying it's self-defense. Now y'all prove me wrong. Correct?
That's right. That's right.
Yeah.
It used to be that this stand your ground hearing, you would be introducing evidence as a criminal defendant.
Oh, I see.
To justify
I missed that.
your defense. Yeah, your use of deadly force. But
so the
now
defendant doesn't have to prove, the state, that's what you said, the state has to prove this wasn't self-defense.
right. So there will be a hearing, and then the state will, I guess in the Lawrence case, I'm sure they introduced the obvious, hey, the door was solid.
Yeah.
She wasn't armed. She had no reason to think that this woman was going to get through the door and harm her and cause great bodily harm.
Yeah.
At least not at the point that she shot that gun.
That's interesting.
Is there any case law of a civilian feeling threatened by a police officer and shooting a police officer that you know about?
I'm not familiar with any such case law. I'd be surprised if that's not a scenario that's played out at some point in Florida as the stand your ground laws have applied here.
Yeah.
Because
So interesting.
me sitting in my vehicle and you stop me for a traffic ticket and you end up knocking out my window, shattering my window, pulling me out of my car and fighting me or beating me aggressively, I'm thinking I'm about to die.
Hello.
I'm going to defend myself. Anyway, that's just me. Let's move on.
I understand.
Yeah.
Okay, I have a question that has to do with you being a criminal defense attorney. So tell me if you're like, I got clients, I can't answer that. That's fine. Okay, I understand.
I won't give you any specific details about any cases. I'm happy to answer your question.
One of the things that was brought up in the Susan Lorenz case, the defense attorney spoke about her age and her ailments, and she broke a hip, and she was frail and a lot of things. Okay. And as not a lawyer person watching this, I was like, girl, this is quite the stretch. But okay, that's the preface. Okay, context for my question. As a defense attorney, when you are having to be creative, okay, about the defense, how does that land with you? I guess, like, what is the process of being a criminal defense attorney? Somebody comes and you're like, let me figure out all the ways that I can defend you. And even if I don't believe them, let's see if I can convince somebody else. Like, can you walk me through a little bit of that?
Sure. I think the best way to look at it, I get this question a lot, right?
Okay, good.
Would you defend a murderer? Would you defend a rapist? Our job isn't to wave a magic wand and trick people into thinking that something different happened. The best way to look at it is we are on opposite sides of justice as lawyers in a criminal case, right? You have the prosecution on one side, you have a criminal defense attorney on the other side. It's a yin to the yang. If we don't have both sides adversarially litigating against each other, then where's the justice? Where's the justice? And so our job as a criminal defense attorney then is to make sure that we're doing our due diligence for our client and leaving every stone turned,
Mhm.
leaving no stone unturned,
Unturned.
so to speak.
Uh-huh.
And then we're leaving it to the jury, to the fact finder, whoever that may be, to determine justice. And
Yeah.
our job as lawyers is only to advocate for our client in whatever role they may play in the case, and that's it. And there's lawyers on both sides,
Yeah.
good people on both sides, as 45 would say.
I was
Yeah.
gonna say, I heard a man say
Old
that
dog
before. Are there people you do choose not to represent?
I choose not to represent people if I don't think that I can help them. If I don't think that that I can do anything for their case, for whatever reason, but not because I have any. I haven't found a case yet where I have any personal,
Got it.
moral issues with the case. Because the way I see it, whether I represent this person or someone else, um, that person is entitled to a defense. They're
Mhm.
entitled to it, and so it doesn't mean that they're going to get off or anything like that. It just means that in order to keep this system honest, you have to have good advocacy on both sides. It's the
Yeah.
only way to call the system honest and fair.
Yeah.
Hmm.
Go ahead.
No, I'm trying to remember what I was about to say. Go ahead.
We watch a lot of trials around here, and one of the things that comes out a lot is Brady evidence and the prosecutors not turning that over. Is that something you experience frequently in your line of work, in your everyday?
I haven't had to bust out the Brady rule on any prosecutors yet. Thankfully, that is an ugly thing. I do suspect that some foul play, and none of which I can prove, amongst prosecutors and law enforcement in some cases that I've handled. And it's just the way of the game. As criminal defense attorneys, we know that the deck
Mm-hmm.
is stacked against us.
Yeah.
So, are you a state employee, or are you you have your
No,
own firm?
I'm a criminal defense attorney. I practice. I ran my own business for about 7 years, and just last year I joined a firm, and these days I'm practicing mostly family law and criminal defense.
Okay. I was wondering how you get your cases. Yeah.
Just word of, 10 years here in Florida. I just word of mouth,
Okay.
building my reputation day by day.
Cool.
Are you in your spare time watching trials at all? I imagine the answer to that is no, but I have to ask.
I do keep up with the legal news around the country as best as I can. I heard y'all talking about the YSL trial
Yeah,
a
child, that's
little
really why I
earlier.
asked.
It's fascinating. It's a fascinating thing going on up there. I wouldn't dare to say that I know even half as much as you all do on that case, because I haven't been paying enough attention. But I think that there's some historical stuff going on there in Atlanta, and I can't wait to see how that all plays out.
Me either.
Question for you about staying your ground. I'm sorry. Do you think that this law is controversial? Like, does it cause people to really okay, for example, if I have a gun on me, I'm probably going to stand my ground and confront you. If I don't have a gun on me, I'm gonna figure out a way to get away from this situation. But now that I have a stand your ground law, instead of figuring out how to get away, oh no, I gotta stand my I got this law behind me. So instead of fleeing and we both live to fight another day.
That's the problem with the law, right? Is
Yeah.
that it gives people perhaps a false sense of security,
Mm-hmm.
Yes.
Mm-hmm.
and security from criminal prosecution, to be
Mm-hmm.
exact. But there is, you have to find some balance between giving people the right to protect themselves, but the stand your ground law, I think, is the type of law where if you're going to introduce it, then you also have to make sure that people are educated about it.
Mm-hmm.
and so that they don't make the mistake of misunderstanding, how that law applies to them. Not everyone has to be a lawyer, but perhaps they should understand the stand your ground law with as much um, under with as much conviction as possible before they think in their mind to try and claim the protection of the law.
Yeah. I have two more questions and then I can let you go. One is from the Patreon. There is someone who, a woman named Sarah Boone, who has been in the media a ton. She has gone through 8 attorneys. I think she just got assigned another one, public defense attorneys. And the question they have is, have you ever heard of a person going through that many?
That many attorneys, 9. Wow, no, double digits. No, I've seen some cases, with multiple attorneys over the course of just a few short months.
Yeah.
It happens. The thing is, I've never filed a motion to withdraw as an attorney on a
Oh,
case.
interesting.
Well, I filed them. Let me finish. I never filed one that had any more detail than this ain't working out.
Okay.
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 And the court really respects the attorney-client privilege and relationship and all that, and so they really don't go into any more, typically any more inquiry than just that. Is that the attorney-client relationship has broken down.
Okay.
So I say all that to say that we don't know why she's gone through 8 or 9 attorneys, and we probably never will because it's confidential.
We can assume. You can't. We can. We can assume.
Certainly.
Okay, the last question I had, just because you mentioned education, and one of the things that we do on this podcast, we have a section called Mel's Minibar, because even though I'm not a lawyer, I read some books sometimes, and I read just a ton of information trying to understand what it is we're watching. And so today I talked about the Alford plea and the case that originates from. So we do things like that. And so with that said, and you mentioning all these cases that exist and all of that, I'm catching you on the spot, so if you're like, girl, no, that's fine, but is there any cases, anything that even if it's from law school, that was just so interesting that you would recommend non-lawyers to read about, know about, you guys should definitely know about this case? Is there one you would recommend or suggest? I know I said I was catching you on the spot.
Yeah, that's tough. That's tough. I mean, give me an idea of maybe a type of case. I mean, I guess you're talking criminal, right?
Yeah.
Or
Well, any case. It could be anything.
a case in which that y'all should look up. So perhaps like a famous case. I think it's important.
Or I was going to say,
Ah,
or just important, because we also, I didn't know the Brady, the actual case, John Brady. So that's another one that we talked about. So really, if anyone that you're you guys should know that this comes from this, or this is just really
well,
interesting.
you know what? This came to mind. I'm just gonna say it.
Okay.
So we have an election this year.
Yes, we do.
And the polls, the feeling, the vibes. I'm from California. We deal in the currency of vibes. The vibes tell me that Kamala's got the votes.
Mhm.
Okay, but people that are interested in looking at old cases should look at Bush v. Gore, 2000,
Yeah.
and you will see that the Supreme Court decided the presidential election that year. And I say all that to say that we've got a 6-3 super conservative majority in the Supreme Court right now. We have a justice, Justice Uncle Thomas, that has pretty much come out and said that that he's willing to do some things, and we also have a former presidential candidate, current presidential candidate, that's already shown that he's willing to use the courts fraudulently to try and steal the election. So people should look at Bush v. Gore, the 2000 case,
Okay.
and look into that with that background.
That's a good recommendation actually, because I have never looked into it. I was young probably too, and well before I'm Not a Lawyer But days.
You said Bush and Gore?
Bush v. Gore, yes.
The
I
case
mean,
is Bush v. Gore. It's a Supreme Court case. If you Google it, it'll come right up.
Wow, yeah,
it's referenced so often, but I actually have never looked at that.
There's a lot going on there, and actually, there's a documentary I'd recommend by filmmaker Billy Corbin. I believe it's called 537 Votes, and I'll just leave it there. It's a great documentary on the subject.
I love it. Good recommendation. Look, on the spot. You still delivered. We love it. Thank you so much for being here. Is there any plugs, or how can people find you if they're in the Jacksonville area and maybe are defendant and needing some representation? Whatever you want to share about yourself, where people can find or contact you.
No, I appreciate y'all having me. It's good to have a West Coast vibes reunion here. And all I'll say is that I'm making plans to be bi-coastal, so look out
nice.
for some things. Coming in the next couple of years. I think I'm gonna take my talents back to LA.
I love it.
That's what's up.
Thank you.
All right. Thank you so much.
It was nice meeting you, man.
Of course. Nice to meet you both.
All right. All right. Thank you to Obi for joining us and informing us. That was a really good discussion and conversation. I feel like we've learned a lot.
Take your time with self-defense and stand your ground, because you will be locked
Everything
up.
ain't stand your ground.
Yeah, everything's not stand your ground.
Ask Susan Lorenz.
Yeah.
And so with that, thank you again to him joining us. Thank you guys for being here for this episode. Until next time. Well, I guess we should close out. I'm Not a Lawyer, but you can find me on all the platform as that. And how can they find you?
Find me on IG. That's GOOLZBY, Building with Goose on YouTube.
So all right, there it is. Until next time.
Court's adjourned.